Good morning, everyone. In the hope of starting at 10:30, I'm going to start with a couple minutes of intro, do our backup stuff, and talk about the assignment. So all your fellow students who are not here, sorry. You will have to tell your colleagues how things are working. Today, we're going to have our guest speaker, Pam Samuelson, but first, I'm going to start off with AI news you can use. Now, you remember Tuesday's lecture. Remember Andrew Chatham from Waymo came and spoke? And I couldn't help but put in a couple of Waymo things. Here's a Waymo thing from this week, in fact, from I think yesterday. DoorDash is now delivering your baked goods or your burrito or your pizza with a Waymo. So when your delivery is ready, you can actually request a Waymo to deliver your food. So it's DoorDash automated. Basically, if you go watch the video, it's the person who puts the bag of that DoorDash into the trunk, closes automatically, drives away, boom, gets to your house, trunk opens, you take the food out. Fantastic. What could go wrong? I want to contrast with what you might have known about already, which is that there's a bunch of delivery robots out there already, right? All these little guys roaming around, not around campus, but around the rest of the world. And as you probably know, DoorDash, interesting enough, has its own delivery bot. It has its own. So it's competing with itself in a weird way. On the other hand, Waymos are bigger, they can carry huge amounts of food, and they're ultra reliable compared to this. The reason is this. That poor little delivery robot just got hit by a train and burst into flames. So the inherent problem with small robots running around like that is they have limited sensing capability, so it didn't notice that the crossing arm had come down. The train has no ability to stop, and so if a delivery robot goes on the tracks, train's got no choice. It's not a trolley problem. It's a I'm going to run over this robot problem. So this is a real issue. The other thing that got mentioned on Tuesday was the trade-off in between different companies trying to build robo-taxi services. And Tesla, the other company referred to, has had to scale back for exactly the reasons we were talking about on Tuesday. They have a huge regulatory problem. Lots of cities, including San Francisco, said, yeah, you can have this robo-taxi, but it has to have a person sitting in the seat. So every time you order a Tesla taxi, it comes with a human. So the difference between that and a regular taxi is what? So they're clearly trying to do training and all that kind of stuff. But if you read this article, it goes into a lot of detail about what the trade-offs are and why they're going to be behind on their expected delivery date. As you probably know, Elon said a couple of years ago, he's looking to have half the US population served by Tesla taxis in the 2025. Tomorrow, the day after tomorrow is November 1st. Not going to happen. So let's talk about assignments real quick. Assignment number 3. Thank you for everybody turning their assignments in. We are grading it now. You will be getting emails from us saying, please make your document readable. Please make it editable so we can leave comments, the usual sort of thing, right? I found one person who put a link to a YouTube, but the YouTube is private. So don't do that, right? I need to be able to see it. Tobias needs to be able to see it. Peter needs to be able to see it. So next assignment, number 4. Number 4, as you remember, is the final project. So what you're all going to do is give a presentation in class. We have 2 dates, the very last day of regular class and our special date on December 11th, where we will have an extended period of time. If you cannot attend one of those classes, let me know. Better yet, put it in the spreadsheet. There's a master spreadsheet, and I've given links everywhere, where you put in your team members, what the title of your talk is going to be, title of your research, and ultimately you put in your link to the slides and all that, okay? So figure this out, and if you don't have a team by November 13th, show up here and we will fix that problem for you, okay? Any questions about assignment 4? while we're thinking about it. Any thoughts? We're all good? Okay. The teams you had for number 3, you can keep them for number 4 if you want, but I know a few people have already contacted us and said, hey, could I do something slightly different? Fine. Mostly. We do that. Okay, so that's for later. Let me switch over now and do a quick intro because I want to maximize the amount of time that Pam has to talk. There we go. Good. So this is Pam and Samuelson. She's probably the best known AI IP legal person in the universe, certainly in the US. Right. So she's the Richard Sherman Distinguished Professor, we bow to you, at Berkeley, and she's between law and the iSchool. So let me see. She's a co-founder of the Authors Alliance and co-director of the Berkeley Center for Law and Technology. So she's one of these people you have to know about if you're going to think about copyright, AI, and IP. This is the person you want to look for. She's written a bunch of articles, all of which are brilliant and well worth reading. Fun factoid, she's a graduate at both the University of Hawaii and Yale Law. Not many people can say that. So, Pam, the floor is yours.
Thanks.
Thank you for coming.
So I've been spending a lot of time thinking about generative AI and the law, and in particular about copyright, because there are now 56 lawsuits challenging the legality of generative AI, most of which is on copyright. So I want to give you kind of a little bit of an overview of that, and then I'll kind of go through the basics of copyright that are relevant and about the cases that have actually been.
Okay. You're good.
Okay. Take 2. So this is where we're going, and we may not get all the way through it because you may be interested in some parts of it more than others, and I'm here to kind of like find out what you're interested in and what your perspectives are, because obviously there wouldn't be 56 lawsuits going on right now if there wasn't kind of at least the controversy about these cases. So most of the cases are class actions. And what class action means is that a relatively small number of people claim to represent a class of all of the people, usually book authors, but all of the people who own some interest in some copyrighted material, and they try to persuade the court both that the defendant is a bad guy, but also that they are representative of the people that they claim to be part of the class. And so there's one class action for visual artists. There are numerous lawsuits to represent book authors. There are a bunch of individual non-class action lawsuits: Getty Images, Concord Music, UMG, New York Times versus Microsoft, and Disney versus Midjourney. So there are lots and lots of lawsuits. Almost all of them have a major claim, which is that the training, the making of copies of copyrighted works as training data is copyright infringement, regardless of what happens thereafter. Now, in cases like the Disney versus Midjourney case, they're talking about outputs too, right? Because that Midjourney can allow you, if you want to see a particular cartoon character or a particular like Iron Man or something like that, they will let you kind of like ask for the creation of an Iron Man doing the laundry or something like that. Okay, so so that's an output claim, but most of the claims are input claims. What are the motivation for the lawsuit? Well, the class action lawsuits are ones in which the lawyers see a potential for humongous awards, because many of these cases involve works that were registered with the Copyright Office, which makes them eligible for statutory damages, which start at $750 per infringed work, going up to $150,000 per infringed work. And when you're talking about millions and millions and millions of works that are in the training data set, you can see that even 750 times that many millions gets to be a very large number. Okay, so there's really a lot of money at stake in these cases. And the lawyers usually get something where between a quarter and a third of the take. So you may have heard that Anthropic recently decided to settle one of the lawsuits, which I'll talk about again in a minute. And the lawyers have put in for, and the court has given preliminary approval to $375 million for the lawyers. Ka-ching. Okay. Now, that isn't to say that Disney and the other plaintiffs, like New York Times, they aren't interested in money too, but they don't get the huge multiples that the class action lawsuits do. But one of the things that many people who are in the technical field don't really grasp is that a lot of authors, a lot of artists, a lot of creators really don't like generative AI, really object to it because you didn't ask our permission, you're making money off our stuff, and you didn't give us any credit, and that's really terrible. And the generative AI outputs actually compete in the marketplace with my human authored stuff, and that's terrible. Okay, so this graphic is really the best example of how graphic artists think about generative AI, and they get really, really angry really, really quickly, and so there's an enormous amount of anxiety in these fields. Okay, so copyright is a really complicated law, but here's the stuff that you need to know going forward. Okay, so copyright law attaches to original works of authorship from the moment that the work is first created and fixed in a tangible medium. So that every time you take a photograph, every time you take notes in class, every time you send an email to somebody, that's an original work of authorship, which copyright law attaches to, even if you don't have any kind of intent to exploit it. That's the way the law is set up. When you get a copyright, it gives you the right to stop other people from making copies of the work, preparing derivative works, and controlling distribution of copies and public performances. The rights last a really, really, really long time, but the copyright only protects the original expression of authors, not ideas, facts, etc. And its scope of rights is limited by this doctrine called fair use, which I'll talk about in a minute. Part of actually why the generative AI companies think that what they're doing is actually okay is because they think that what they're trying to do is not exploit the expression in works so much as use the works as data, right? You kind of like analyze them to like break them up into little parts and basically analyze and sort of understand statistical correlations between these words and other words that are similar or different or whatever, okay? So there are lots of unprotectable things in copyright law, and I've listed them here. I don't want to go into detail, but you can see that what is an expression? An expression is basically about the words that I say, the song that I write, the kind of the play, but it's got lots of stuff in it that's not protectable, and that's why it's plausible. So I think it's actually good to have an example of where something might be academic misconduct, but not necessarily copyright infringement. So Ho and Tavlov were both engineering professors at Northwestern. Ho developed a mathematical model for how electrons behave under certain conditions. And he had a graduate student working for him who later went to work for Tavlov. And Then Tefloff and Chang published a paper and then a book chapter about Poe's model, using not only the theory, but also some figures and some tables and text from Poe's writings. And Poe sued for copyright infringement. Court basically said, the mathematical model is an idea, is not protectable by copyright law, and the figures that are used in the paper and the book chapter are things that basically embody the kind of the factual stuff in the work, and therefore it's not infringement. So did Tefloff engage in academic misconduct? I think the answer to that is yes, not copyright infringement. Okay, here are a couple of other things that I want to plant before we get into the specifics of the cases, and that is that copyright law has a grounding in the Constitution. And the constitutional purpose of copyright is to promote the progress of science, that is to say knowledge, for the public good, right? So it's really that's what its ultimate goal is. And the exclusive rights that are granted to authors is simply a way of trying to achieve that. But it's also intended to give authors incentives to create and disseminate their works. Fair use is a limitation on those rights to provide a kind of breathing space for new creation. And at a time of rapid change, especially technological change, it actually provides a little bit of like something to flexibility, so you can kind of decide where it goes. And the Supreme Court has talked about fair use as a context-based check that can help keep the copyright monopoly within its lawful bounds. So here is the kind of like the overview about fair use, and then we'll get into it. So fair use is a fair use of copyrighted works are not infringements. It's a defense. So defendants raise it after plaintiffs have made a plausible infringement claim. And courts consider 4 different factors. 1 is the purpose and character of the use. 2 is the nature of the copyrighted work. 3 is the amount and substantiality of the taking. And 4 is the effect of the challenge use on the market for the work. Okay, so that's the basic. A really important decision that's kind of a landmark in copyright is Campbell versus Acuff Rose, where Acuff Rose sued Two Live Crew because they made a rap parody version of a Roy Orbison song, and Acuff Rose doesn't have a sense of humor, and so they basically sued for infringement. And the Supreme Court said that this parody was a critical commentary on the original, and it was consequently transformative, right? It was for a different purpose, it conveyed a different message, and therefore it was something that furthered the purpose of copyright, which is to, again, provide that kind of breathing room. And the court decided that how much they took was reasonable in light of their purpose. And I think you can see that that nobody was going to buy the Two Live Crew version of the song if they really wanted to listen to Orbison. Okay, that's the idea. I'm giving you this one just to sort of see how it goes. But I'm going to move to the generative AI cases, because this is a place where the big controversy is. So if you see here, the plaintiff's theory is that the purpose that many of these companies, and pretty much every one of the big generative AI companies, is at least the defendant in one case. I think OpenAI is has a target on its belly for 15 cases or something like that. But they say, hey, it's commercial. Whenever it's a commercial use, that actually a commercial purpose, that actually cuts against fair use. And they say it's non-transformative because you're making exact copies of the works and putting them in a database for the training data. And bad faith, because a lot of these companies are using pirated books that can be found on the internet to train their models. And that is something that they say is bad faith. the nature of the copyrighted work, creative expression, the amount and substantiality. You're making copies of multiple copies of entire works, and that doesn't sound like it could be fair use. And the outputs compete with our work, and we're losing licensing, right? That's the kind of the story kind of you're telling in this particular case. And the defendants, surprisingly, have a different view of this. And they say the purpose is highly transformative, right? When I'm basically taking, here's a book that I found on the internet, and I put it in a training data set, I'm using it for a different purpose, right? What was the original purpose? It was to entertain or to educate or whatever. And if I'm using it for a very different purpose, such as training a large language model, that's transformative. And when something is transformative, even though if it's transformative and commercial, well, the commercial doesn't weigh as much against it if it was transformative. And the more transformative it is, the less the commerciality matters. The nature of the works, again, they basically say, look, we don't care about exploiting the expression in the work. And most of the works that we're training from are up on the open internet. And if it's not on the open internet, that's really the targeted issue is then if you don't want it to be copied, you can use robots.txt as a way of saying, signaling, don't copy my stuff as part of common call. And we say it's reasonable in light of our transformative purposes, and the outputs don't infringe or supplant demand for the original, and markets for licensing are impossible. Okay, so these are the two kind of starkly different points of view on this particular set of issues. And the first case that we went to trial, or was decided by a trial judge, was this case called Thomson Reuters versus Ross Intelligence. The case is now pending in the appellate court in the East Coast. So Thomson Reuters owns Westlaw, which is a computer database of legal materials. Now, the judicial decisions, statutes, and other things that are law are not protectable by copyright law. The long history of saying government edicts aren't protected. But what West does is that for each of the opinions that courts actually render, they kind of select out of the decision what they think the key points are, and then they try to summarize it in a really concise way. Now, sometimes that involves exact copying of sentences from the judicial opinions. But Ross basically was able to get 25,000 of these little head notes that are like, again, a description of what the cases actually say from a third party. And Ross trained on those head notes, but it doesn't embody and it doesn't output the Westlaw head notes. What it outputs, so if you are a person who wants to ask a legal question of Ross Intelligence's machine, you basically sort of say, you know, is this particular thing a trespass on land that I could be liable for? And what the Ross thing will do is spit out to you some text from a judicial decision that basically says what a trespass is or what it isn't. Okay, that's kind of what's going on. So the trial judge initially was going to send the case to a jury, but then he changed his mind and he decided pretty much along the lines of the opinion or of the argument that I saw here. Okay, so it was commercial, was non-transformative, it was creative expression, entire works, and the goal is to compete. So the plaintiff's theory won at the trial court level, and the question is what's going to happen on the appeal. Now, after the judge in the Ross Intelligence case made his decision, two other cases basically were decided here in the Northern District of California. So Bartz and Kadri are both book authors, and they are lead plaintiffs in class action lawsuits against Anthropic and Meta. And the generative AI defendants basically said, please judge, rule as a matter of law that my thing is fair use. And so there were arguments this last spring, and in June, the judges basically decided those cases. The first one to be decided was Bartz versus Anthropic. And here, on the training data issue, the judge went completely on the defendant's side. Okay, so the defendants won. The training data uses are quintessentially transformative because of different purpose. Books are creative works that are chosen for training data because of their expressiveness. But it's necessary to copy the whole thing for your transformative purpose, and you're not supplanting demand for books, so there's no harm to the market. And super interestingly, one of the arguments was that Bartz basically says, "Hey, I want to license this use of my book to you, Anthropic, and so by not giving me money, by not choosing to license, you're depriving me of licensing revenues, and that's bad." And the judge basically said, authors are not entitled to licensing fees for this kind of use of their works. Okay, so it was so transformative that the court basically said it's not interfering with any kind of market, and it's basically allowing a really creative thing to happen. So sorry, Bart, but downloading collections of pirated books and storing them in a database was treated completely different. So judge basically said, well, how many pirated books did Anthropic use, download and then use from LibGen and some of the other pirate sites? 7 million. Now, you can imagine going before a judge and saying, hey, judge, I downloaded these pirated books and I knew they were pirated books. I was just using them to train the model, and I wasn't using them in any way that was really exploitative. And the judge said, oh, you've got to be kidding. Okay, so that decision then says that this is fair use. The training stuff is fair use, and that was a big ruling, actually. Yeah.
The judge has a record or experience in dealing with a lot of computer cases. So
yes, Judge also
more knowledgeable.
Yeah.
Than other judges.
More technically sophisticated. Yeah, yeah. So maybe you heard about the Oracle versus Google case about parts of the Java API. It was a big deal a few years ago, but you probably were in high school at the time. But anyway, but that judge was the same judge.
Took it upon himself to learn that program.
Yeah, exactly, which is amazing. Anyway, another thing that Anthropic did that the judge said was fair use was that it actually purchased a bunch of physical books and then digitized the contents of the books and then used those as training data. And the judge said that's fair use too. Okay, so 2 really important things that went in the favor of those, but obviously the pirated books thing was treated differently, and the judge was really intent on going to trial on that. So one of the reasons that Anthropic was willing to settle for $125 billion is that the judge had set a trial date for the pirated books issue on December 1. And remember how many books? 7 million books times a minimum of $750 per infringed books. The liability that they were looking at was so large that 1.5 billion just seemed like pocket change to them. And so the case is actually, the judge has given preliminary approval, which doesn't mean that it's going to finally get approved, but it probably will at this point. Now, the Kadri versus Meta case kind of was similar in some ways and different in other ways. So cadre has agreed with Judge Alsop that Judge Chavria agreed that they were highly transformative, even though they were also commercial. But for him, the pirated books issue didn't cut either way. Right? He said it didn't move the needle. Okay, so you have one judge who says, "Oh, pirated books," and you have another judge who basically says, "Well, so what?" Okay, so these are two different approaches to it. Agreed that the entire works, creative works, were the same, and also agreed with Judge Alsop that lost sales and lost licensing revenues theories were really not persuasive at all. But Judge Chavria got really excited about a concept called market collusion. Now, let me say a little bit about what market collusion means. So, I'm a human author. I write a book. I write romance novels. I write gardening books. I write about mushrooms. I write about anything. And now, anybody can basically use one of these generative AI systems to create gardening books and mushroom books and romance novels. And the market gets flooded with all these AI creations. And if it gets flooded with all these AI creations, then people aren't going to buy the human author works anymore, or they're going to buy much less. I won't be able to make a living from my work, and therefore, even though there's not a direct market substitute, the judge thinks that there was an indirect market substitute. Okay, so that's a theory. But Cadre failed to plead or offer any evidence of this market collusion theory, and so meta won. Okay, that's kind of what's going on. Now, this is basically to say, right, it's a flag to the plaintiffs in the other cases that are pending. Just go after market collusion theory, right? Look for that evidence, plead it, find some evidence, and then the various decisions will go the other way. So this is really interesting, right? That these first two decisions came out within 2 days of each other, and there's a story there. So comparing the two, right? Highly transformative, rejected the control of the training data licensing market, but very different on pirated data and very different on the market collusion theory. And I'm curious, since some of you might actually have some thoughts about the pirated data issue, how do you think that should be thought about? Very used to use it? Yeah.
I feel like it's really interesting how you said like each infringement is a minimum $7 like on the piracy issue, you have, like these books individually cost like say $23. I think like in that specific case, I feel like there's kind of like disconnect between like the disconnect between like the kind of lots of damage that was done to like the plaintiff, and then like the amount of money that if this were to actually go to court not be settled, that the defendant have to pay in a case of the piracy conspiracy.
One of the things that's actually hard is that it's pretty clear, at least from the computer science people that I talk to, that even 7 million books is a kind of drop in the bucket. And so you kind of like say, here's kind of all the books in the world that have been digitized. How much does any one of them, or any like collection of them, how much does that affect the language model? And is it possible to do any kind of tracing? And at least so far, I think the tracing problem is significant. So that's one of the things that makes these cases kind of difficult, right? And also try to think about what would it be like to try to make a license or get consent from every one of 7 million or 10 million authors. And besides which, we don't know who owns the books, right? So, owns copyrighted books, right? So the basis of these book cases is that notwithstanding, now in the Bart's case, Bart's actually kept her copyright. So Bart's is one of the few who basically said, if there's any rights, but with a lot of these book cases, the author assigned the copyright to the publisher. And so does the publisher own it? Now there are some cases that basically say that if something, if at the time of the contract, a particular type of use was not in contemplation, that the uncontemplated interest remains with the author. Does it matter what the contract actually says? So nobody really knows who, if anyone, owns. And part of what both of the judges are saying is that the author, whatever they own, they don't own training data rights. Right? Basically, by saying they don't have a right to control licensing, is basically to say they don't have any rights at all. Okay?
So the copyright law, precedes any sort of Gen AI's today's capabilities. So to me, and I think this is sort of what you're touching on. I'm wondering though, does anybody saying like, okay, if we were going to make that law a copyright law now, knowing what Gen AI can do, how would we structure it differently? I mean, it just feels like we're trying to apply, we put a round peg in a square hole, and coming up with all reasons why this one squeezes in and this one doesn't. But the law was so much slower than the pace of tech. Is there any place, is there any way where people are innovating on the law itself, given these new capabilities?
So it is one of the things that is challenging, which is that this law that we're talking about was passed in 1976. It was actually drafted in the mid-1960s. And the aspiration of the drafters was that the law would basically continue to evolve in response to new technology. And this one is kind of like, oh God, we didn't imagine this. So what do we do? Now again, part of the thing that I mentioned before is that this fair use concept was viewed as something which would mediate the interests of authors and the public over time, and authors and technology developers. And I kind of skipped over the Google Books case, but there were two Google Books cases that were brought in 2005. And what did Google do? It copied 20 million books out of research library collections. And there are a relatively small number of them were in copyright. And the Authors Guild just went and sued, again, brought a class action, identified 3 of their members to be the class representatives. And they brought a lawsuit. Now, there was a time when that case was proposed to be settled through a collective licensing agreement. But the judge rejected that settlement and went on to say that Google had made fair use of the books. Okay? Highly transformative because for a different purpose. Yes, it was commercial, but they weren't actually commercializing the snippets, right? So you could get a link to a place where you could buy the book or to borrow it from a library. So they weren't supplanting demand for the original. It was books of all sorts. If you want to index the contents and if you want to basically make it possible for people to search for snippets, you got to copy the whole thing. Okay? And so the market effects was seen to be, by the judges, was seen speculative and not actual. And so if it's speculative, then there's no harm, right? So that's the case, right? If you're going to say, of all the cases that are out there, this is the one that the generative AI developers are really counting on the most, right? Because, again, digitizing this many books and then using them largely for non-expressive purposes, right? You want to just like index the content so you know what's in them, and snippets in order for people to be able to find stuff that they wouldn't otherwise be able to find. So that was actually a big deal, right? And so in 2014, I think it was, an appellate court written by a judge who's really famous said, yeah, that's okay. So it kind of emboldened some of these companies to feel like, yeah, we're doing something that's, again, if you think about the constitutional purpose of copyright, is to promote the progress of knowledge, right? They think they're promoting the progress of knowledge, and they're also providing the public with new tools for engaging with content. And, you know, I'm guessing that most of you in here are going to use that stuff. If you think about it, right? If the plaintiffs in these cases are right, and all of these systems are infringing, then you're an infringer every time you use it. Okay? So that kind of puts a little bit different complexion on it, right? So one of the other cases that's a long-standing technology and copyright tension was the Sony Betamax case. So in 1984, the United States Supreme Court decided that the Betamax machine, which Sony made to allow people to make to make tapes of broadcast television programs. Universal Studios and Disney said, you must be joking. And so sued Sony for contributory infringement on the theory that every time consumers used those Betamax machines to make copies of television programs, that's an infringement of copyright. And because Sony is materially contributing to that infringement, knowing that people are going to use the machines to make copies, it's a contributory infringement. So this issue about sort of can individual consumers be infringers, it was before the court. The court basically said, well, if you're using it for time shifting purposes, just watch the program at a different time. That's okay. That's fair use. And Universal is like, what they use. But I think you can see that this kind of like issue about if you use it for these purposes of getting text or images or whatever, are you also an infringer? Well, a number of these lawsuits are making not only direct infringement claims, by which I mean that they're saying these companies made copies of these things and therefore they are infringers. Those are contributory infringement claims and vicarious infringement claims. So what they're saying is you are the direct infringers and the company that provides you with this technology that enables you to do it. Now, from the standpoint of the companies, they want to say, hey, Sony Betamax case, okay, let me go to the other important holding in that particular case, which was that once the court decided that time shifting was a fair use, it said, well, the technology has substantial non-infringing uses because people can use it to make time shift copies. And it's identical. And so a technology that has substantial non-infringing uses cannot be sued. The maker cannot be sued for contributory infringement because of those substantial non-infringing uses. So a bunch of the technology companies and the AI development space would say, hey, our technology has substantial non-infringing uses. And they have substantial non-infringing uses, and you can't hold me liable even if you use it to produce some infringing material. Okay? So these cases that were decided back in the 1980s, right, are coming to be part of it. And when you, let's say, use one of the generative AI systems to get hiring man after longer man, if anybody is a direct infringer, it's you, right? Because you asked for it, right? You made the request. And so the fact is that the company didn't know that you were going to ask that. Now, some of these companies, basically OpenAI in particular, have put in guardrails so that certain kinds of characters and certain kinds of other content basically are blocked, right? I make this request, and OpenAI says, I'm sorry, I can't fill that particular request. Would you like to ask something different? Okay, so that's another way that the companies are going to try to make their arguments about their uses, is that, hey, we try to do these things to limit the extent of copy. But we didn't really kind of answer that question about hybrid books. And I'm interested to see, you know, I mean, part of actually what we know about in the last couple of decades is that ordinary people just don't think very much of copyright law, don't respect it very much. So maybe you've read, maybe you personally downloaded some hybrid books. I'm just curious. That's the issue. That and the market dilution issue. You can see those two issues. The judges are kind of on that one. I'm just looking at you. You told me these people were really. I'm having trouble.
I did portray you all as very interactive. That's your chance to prove me right.
Could you repeat the question?
What?
Could you repeat the question?
Yeah, the question is, what would you do about the pirated book? Right? So you have Judge Chaudhry in a Chaudhry case basically saying it doesn't move the needle one way or the other. Like, it doesn't really matter. Right? And again, part of it is that what copyright law worries about the most is supplanting demand for the original. Right? So if you use a pirated book in order to train a model, you're not consuming the book in a way that copyright law worries about, because that copy is not going to mean that you don't go out and buy the book, right? So it's kind of supplanting demand for the original is one of the kind of what Supreme Court has called the bête noire of copyright, right? I mean, that's what we want to watch out for. And so if that's what you think, and you think that the pirated books, actually, the contents of the pirated books are contributing to knowledge, right? Because they become part of the language model, and therefore that they are, you know, allowing us to use more words and understand things better. Maybe that's a good thing. Okay?
I feel like it comes down to like the harms, like the outcomes. So like whoever wrote the book, the authors of the book, are they losing out on substantial monetary gain because now this model has all of the words and books and everything they put and their work in the training? And if you can prove yes, then I think there's obviously issues there. I think also on top of that, it's also like, could a user access the model and get a whole printout of a New York Times article or a book? And if so,
That's not the way these systems typically operate.
yeah, they shouldn't operate like that. I think I've heard of cases where
Yeah, there are people who have computer scientists who have been experimenting to try to find out how much have some of these models actually memorized. So a paper that I just saw presented last week said, I was able to get almost a complete text of one of the Harry Potter books out of Meta.
Yeah, so like, I think having those guardrails, like in practice, I think having access to those books for the pure purpose of training, because it's just words and structures, using it to like become a smarter system. I think that's valuable if the guardrails are in place for stuff like that.
Yeah. So it's interesting that in the Cottery versus Meta case, the judge was persuaded that Meta had put in enough guardrails so that they couldn't outbid more than very small, really small parts of actual existing works. And for the most part, they produced new stuff, right? Things that weren't in the training data, but that draw upon the knowledge that was embedded in these works to create syntheses, which you use when you're kind of like playing with it. Yeah.
So we have my brain kind of really goes to, I think about training data in books is like what the line is. Because obviously you mentioned like we're training on like that's just data for training. And the output could be completely different. At the same time, like where my head goes to this, what if the models just started out and it's literally just the only input so far is that single book, which is enough, training data to make a really, really small model, like a small language model. And so with that, like, I mean, that to me would be a blatant, use of, violation of copyright. But when, how many voices, how many books can you combine within that model before that model considered, not a blatant violation of the copyright. So that's kind of where my head goes. So I'd be interested.
Yeah, so one of the things that's like a little bit of a curiosity here, I think we can all sort of agree that if we're talking about a very confined body of works, where it's like a bounded training set, where you could actually get permission from those people, right? So Adobe has a model that was built on images that were part of Adobe's. The Firefly is basically based on stuff that they have the rights to, or they have a right to make something. That's one thing. But I kind of like to say, when we're talking about all the content on the internet, well, you go out getting permission for that. So let me jump ahead to another one of the issues that I've been grappling with lately, and I've just written a paper on this part too. So here's the thing that you hadn't thought about either, right? So what happens if the training data uses are infringements? So lost licensing revenues might another judge might actually think differently than the two judges that have ruled on it so far. Defendants' profits attributable to infringement, statutory damages, I mentioned that already, injunctions and impoundment and destruction. So about 9 of the complaints in these cases ask for the court to order destruction of the models that were trained on infringing data. And that's a pretty big thing. Now, the judges don't have to grant that. They can basically say money is enough. But one of the things that some people have talked about is collective licensing, right? So you have right now with copyright a kind of all or nothing, right? So if the defendants win these cases, then they can basically continue to do all of the training without permission that they want. And if the plaintiffs win, $gazillion are at stake, so there's going to probably be more than one settlement out there. But it's a kind of all or nothing thing, right? And so one of the things that, at least in Europe, that there's a lot of talk about is a collective license, right? So the collective license would mean that companies would have the legal right to engage in training uses of works, but they have to pay something for either the training or they have to pay something as an output, on output. So their commercialization would be like some tax, right, or some levy on their commercializations could go into a pot that then could, if not be distributed to individual authors or artists, would nevertheless provide some support for authorship writ large. Okay, so that's kind of an attractive idea, right? Everybody gets really a nice idea because it's kind of like this all or nothing thing. Copyright sort of seems a little stark in both directions, particularly since the lawyers are the ones who are really gonna make out big on these cases. So so I think that's a really attractive idea. It's just that I can't figure out how to make it happen. So there are lots of practical problems with a collective license. So one is that who do you get this permission from? How would you go about getting permission? Right? You just give a blanket and then you collect a bunch of money, and then who do you give the money to? How much is it going to cost to set up a collecting society to get this much money to this person and this much money to that person? And I think you can see very easily that the transaction costs of setting up the collecting society and figuring out how to dole out the money is going to like swamp the cost, or will swamp the money to support this, and you don't know what value any particular work adds to the whole thing. So it's kind of a mess. This is a really deep puzzle, and I think you can see that in some sense that market pollution theory is kind of like, right, apart from the pirated books issue. What do you think about the market pollution?
How much money was I gonna make from my book anyway?
Yeah, it's very real.
Maybe it's not my living, right? Because only a tiny fraction of authors actually can make a living off of them.
Well, one thing that isn't clear. Now, the book authors basically say, look, the reason that you're training on our stuff is because you think our stuff is like super well constructed, that it's very expressive and worthwhile. But nobody can say how much this book contributed to this. And it may be that some of the Reddit posts, which are more conversational, are actually more valuable to how the language models operate than the books, right? Now, we don't know. But what I know is that there's a lot of extortion possibilities here. And so I'm actually against extortion. And statutory damages are the worst part of this whole thing. Yeah.
So my theory is, we set up this robot text protocol where you can say what you want to be allowed for. But one character we left out of that protocol was the dollars. I think we could solve a lot of this in an easy way by saying, yes, here's this page. If you want it to cost 5 cents, and here's the protocol that you use to pay. Even small costs would change the equation.
Yeah, there is actually a proposal out there right now under consideration, which is exactly that. It's called RSL, Real Simple Licensing, and it's a proposed protocol. And it would actually say, if you scrape my stuff, you agree to pay me so much money, and thank you very much. I would like it. Now, one of the things that doesn't do is help you with distinguishing, let's say, researcher and student scraping. So is real simple licensing going to be like everybody has to pay, or is it how do you distinguish which companies have to pay and which companies don't have to pay? And do you really want to have a situation in which scraping, essentially, how do you get the money to whoever, right? Because suppose you're scraping stuff that actually is, let's say, in the Thai language, right? So, how do you know who in Thailand you're going to get money to, right? But because it covers global situation, and there isn't kind of global governance system. Now there are treaties that most countries have entered into about copyright. They're really pretty similar, although most countries don't have what we call fair use. They have other things, and so there's like differences among countries about that. And European Union is talking about the possibility of having a collective license regime. So they created back in about 6 years ago, they created an exception to copyright to allow text and data. And the general opinion is that even though generative AI training wasn't in contemplation at the time that they passed that particular law, that text and data mining exception actually applies. But it requires if you're a commercial entity, that you have to allow copyright owners to opt out. And if on top of that, you have to pay a license fee, well, are we going to let the European Union collect money for content that generative AI companies do that's US-based, or is it only going to be European? And how can you tell which content on the internet is European, and which content on the internet is Japanese and Hong Kong? I mean, you can do a little with the language, but language is actually not going to do a whole lot of good. So this is like and this is really complicated stuff. Okay, so that's actually the collective licensing problem is big. Yeah.
So when radio was invented, the song publishers and the radio stations got together and they made this ASCAP protocol, and that seemed to work pretty well. So how did that work out, and how did that compare to the current situation?
Yeah, I mean, I think that part of what we're looking for. Now, this is again, I'm going to riff on this for a minute and come back here for it. One of the things about law and lawyers is that we carry around a very big bag. Here's all the cases, and here's all the statutes that are on the books, and here's all the law. And I'm dragging this thing around. And when any particular problem comes up, I open up the bag and try to see what's inside and what's the closest thing. That's very reactive. We don't know how to be very good at being proactive, because if we pass legislation now to deal with the situation, it could very well be obsolete, right? So some parts of what Congress did in the Digital Millennium Copyright Act in 1998, imagine a digital future that's very different from the digital future that we have. So some of the laws that we put in the books basically don't work very well because we didn't know what we were talking about, right? We didn't have the foresight to deal with it. So lawyers basically have to go back to what's been done before. Now, one of the things that I think is kind of the magic in computer science technology space is the use of standards. And so standards have been a very important part of governance so far of technology, especially in the internet space. And so the idea of developing protocols that then address certain technical challenges and provide a kind of technical solution is very attractive. And some of them have worked pretty well. And there's a lot of confidence that this real simple licensing idea might actually be a solution to the excessive scraping problem that many of the sites that have a lot of content have been worried about. Like, yeah, doing one line basically says scraping everything on the internet is illegal. I mean, we could do that. But that would have some downside because there's a lot of scraping that actually is done in service of research and good thinking about stuff. And if you put it up and you don't put the robots TXT on next to it, you're basically signaling it's okay. Now, a lot of the stuff that's actually up on the internet, people didn't think about the possibility of generative AI scraping and then training. So there's kind of like a mismatch of like expectations. When I put my sort of my visual art, for example, or my photography up on my website, I wasn't thinking that somebody else could basically take that and do something with it that is not something that I consented to. And that's actually a hardship that, you know, that's one of the reasons why some of these lawsuits have been but I'm trying to help you see what an intractable problem space this is. And again, I want to sort of say, what happens to the nonprofit generated researchers? You know, there are probably quite a few people here in the Stanford campus who basically do some scraping and do some training of models. The commercial, non-commercial distinction is going to be really important. And also, research, scholarship research and teaching are favored uses under the statute. So that to the extent that someone at, say, Stanford is doing this kind of stuff for research purposes, that's probably going to be okay. And a lot of the stuff that the people train on are fact intensive, right? Are things that have lots of facts in them. And the more facts there are, the more useful it is, right? And in some sense, poetry is much less useful for language models than stuff that basically has lots of facts in it. And so that helps. And you're not going to harm the market for the work's expression. Also, there's a really interesting kind of dynamic here, which is that most of the cases involve Microsoft, Meta, Google, NVIDIA, Databricks, etc. Those are all the major defendants in these cases. Of course, OpenAI too, but OpenAI has big investments from other places, and so does Anthropic, right? Amazon is a big investor in that. And there's been, for the last couple of years, a kind of tech flash, right? So the tech companies in the 1990s were like, oh, they're doing all this wonderful stuff, and they're making all these tools available to us, and isn't that wonderful? And that spilled over even into the 2000s when the Google Books cases were pending. But Google is not looked at right now as like, oh, these guys are good guys, right? We worry about content moderation, we worry about misinformation, we worry about hallucinations, we worry about lots of bad stuff, right? And so there are all these bills that have been introduced to kind of like prevent kids from getting access to some of these tools. Not just social media, but also there have been stories recently, I'm sure you've seen, where they're basically saying you should allow kids to make unsupervised use of some of these models because they actually are dangerous for kids, right? And so one of the cases pending now is a case in which somebody used ChatGPT to have a good suicide, and the parents basically sued for that. That's a big deal, okay? Now, that just goes to show that copyright is actually a pretty minor thing. But copyright law now is the only law on the books already that could bring the generative AI thing crashing down. Okay, these cases go against those companies. And somebody decides to try to destroy the models as part of the court order. That's a lot of value that could get destroyed. And maybe, right? I think that if you really believed that market illusion theory that I talked about earlier, right? The market will get flooded with all of this AI created stuff that human objects won't be able to get any sort of compensation again. If you really believe that, then you'd want to destroy the models. Because there's no way that any collective license fee is going to give you $60,000 a year if that was what you used to make prior to the generative AI, right? There's no way, okay? You'd be lucky to get $1,000, okay? And how would anybody know that you were the one who actually individual artist that is no longer getting the commissions, right? So people use some of these models to generate logos and to generate illustrations for conferences and stuff like that. We used to, at Berkeley Center for Law and Technology, we used to have a regular deal with a particular artist to generate our stuff. We don't use them anymore as the model. Now, that's a particular case in which you can say this particular visual artist is not getting paid what they used to get paid. But does the language model have to pay that? I'm just saying this is kind of pretty intractable problem. And maybe they're both. I don't know. Maybe this is just too like.
Time to wrap it up, the 2 more minutes.
Okay. Any last minute observations or questions?
I'm just wondering if you were to treat these models like a human. First of all, are you even allowed to make that stretch? But if you were to treat these models like a human and you had like some non-conscious being that memorized all these texts, what's going on in some other area, and you could ask it, interact with it, say, spit out some new text for me, and it would do so, and it would use all the text that it had trained on, eventually memorized. Would that person be breaking the law? Would you punish them or delete them in this sense and delete the model?
So there are actually conversations happening about whether this generative AI system should be granted legal personhood, right? So corporations are fictional entities, have been for a long time. But we have granted companies legal personhood. Now, one of the reasons why that makes sense is because there are real human beings who occupy the CEO, COO, and other positions that you can actually personally hold responsible, and there are assets. But I don't know that it makes any sense to do that with the generative AI system, because they don't hold any assets, and they don't have consciousness. That would be another, right? There's kind of aspiration, but I think that's pretty unlikely. Anything else?
Hi, thanks so much for the economy today. My name is Harris from Computer Science and Economics. My main question was specifically regarding AGI. I think AGI, once that comes out, and AI is kind of develop its own thoughts in a sense, and actually be creative. I think right now LLMs are not creative. Like every single, I think every single LLM violates every type of copyright law there is, except for at a very minimal level. Because I mean, I feel like anything that I write is somewhat of a copyright because a collection of what I see, what I experience. But what do you think? Let's say AGI is reached within the next 10 years. How do you think copyright law will change next time? what's
Well,
specific.
okay, one of the things about copyright is right now, it's a hammer. It's a nice hammer. It's already on the books. This is reproduction, bang, bang, bang. We can say there's a copy. But copyright can't solve the societal problems that AI generally poses, and certainly can't do what AGI premises are. So you have actually in the European Union an effort to think broadly about artificial intelligence systems as consumer products and to require that they do risk assessment about what risk do these systems pose and what steps have the developers undertaken to mitigate those risks. And they are required on an annual basis to do a report that basically assesses those risks. And so they are thinking about this not so much in terms of copyright, but thinking about it more as a kind of consumer protection regime. And right now, the Trump administration really would like, right? Their aspiration is that American AI systems are going to be the world leader forever. And what stands in their way of that is copyright. And so Mr. Donald Trump is now one of the biggest friends that fair use has. And I expect that some of his Department of Justice lawyers will be dragging into supporting that when these cases are on appeal. So we'll see what happens. Another.
I'm wondering what you think is the most likely, like, maybe quote unquote solution to this problem. Like, I think, like, we have all these preceding cases that have just, like, decided, but it feels like there's, like, some differences between them. They go up to the Supreme Court, like, would they make, like, a landmark rule that it's or do you think it's more likely that, like, Congress would have, like, political marketing legislation to resolve this?
Yeah, I mean, there's the Thomson Reuters versus Ross Intelligence case that I talked about a little while ago. That's going to be decided by the public court sometime probably in the first half of 2026. And Thomson Reuters is a very, very litigious plaintiff. And so if they lose at that appellate court, they'll probably want to take it up to the Supreme Court. And the Supreme Court loves to get quite excited about new technology issues, and so we'll see what they have to say about this. I wouldn't want to take any of the other cases right now, but I think the Ross Intelligence case is one that has a pretty good chance of winning on a fair use defense at the appellate court level. I did an amicus brief in that case. Amicus briefs are a friend of the court, right? So amicus curiae is a Latin phrase for briefs that basically support one or the other of the litigants in that case. And you sort of say, here's a mistake that I think the court made, or here's what somebody else said is a mistake, and I don't think it's a mistake, so here's why. So you basically say, I don't have any stake in this particular case, but I have a point of view about what the law should look like, and so here's my view of that decision. So we'll see. Anyway.
All right. Thank you. Thank you again, Pamela. No class on Tuesday. Just remember, we won't be here. We'll see you a week from today. All right. Thanks.